Afternoon. This is U.S. Immigration Attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. And I have a good topic for you today, and it is children can apply for VAWA as well. So you'll hear me talk about VAWA often, and the name of VAWA is Violence Against the Women's Act. But it does not just, this is not just relief for women. This is relief for all genders. So, men, if you've been mistreated by a U.S. citizen or resident spouse, parent, or adult child, you qualify because, there is a misconception that men can't apply for this relief. Men, you are protected as well, and so are children. So there is a provision. This is not just limited to the spousal relationship as well, but it also covers other types of relationships like the parent-child relationship. So if the parent is being abused by the adult child, the parent can qualify to apply for relief for their own work permit, their own permanent residence without involving the adult citizen child. If the child is the one that's being mistreated, usually this relief is available if the child is under 21 and unmarried. If the child gets married, then they no longer qualify for this relief. So if you're under 21 and unmarried and you were mistreated by a parent, it doesn't matter whether you were mistreated when you were under 18 versus now, you do qualify for this. Also, keep in mind that with the parent-child relationship, it also covers the step parent. So if you have a step parent, I've seen these situations where the U.S. citizen parent takes the child with the immigrant spouse. The parent may also mistreat the immigrant child as well. And if that's the case, and of course, the parents have to get married before the child turned 18. Even if you're approaching 21 now, if you got married before you turned 18, then you would qualify for this. So, you would be able to qualify for relief in this situation where you, as the immigrant child, you were subjected to cruelty or abuse or mistreatment by a step parent, and not just a citizen step parent, but also a resident step parent. If you're out of status, you qualify for this. It doesn't matter that you're not married, you may be in the parent child situation, you do qualify for this relief. What kind of mistreatment qualifies? All sorts. As long as it's mistreatment, as long as it's extreme cruelty, as long as it's abuse, it qualifies, whether it's verbal, whether it's emotional, whether it's physical. But remember, physical violence is not required to qualify for this because abuse comes in different shapes and forms, and it even can depend on your cultural expectations, your cultural norms. If in your culture a certain behavior towards you is considered abusive and is meant to degrade you in your culture, then it is something that can be brought forward as a basis for VAWA. So sometimes it can get complex, but I am here for that, right? I am here to explain the reason why the behavior against you amounted to abuse or extreme cruelty. So it does not matter that, say, in maybe Western norms or in the United States, it may not be considered anything, but say in another culture, it's really a big deal. So go ahead, and if you are experiencing abuse, mistreatment, not from just a spouse, but from a parent or an adult citizen child, the citizen child has to be 21 and up, then you could qualify for this. All right, so I'm going to take questions now. I've pretty much completed what I had to say. You can always follow up with questions about it if you do have those. Go ahead and put your questions in the comments, and thanks for your time as you join me in the live. Hi there, Millie. It's nice to see you. Okay, can I do the deferred status and still marry my spouse? Will that be an issue for them to adjust my status or hinder me from becoming a green card holder? Now, you need legal advice because if you want to get the deferred action for some reason, and at the same time you're thinking about going through the process, we need to understand what your situation is. Because, say, you are requesting deferred action, right? But at the same time, deferred action is usually reserved for individuals that really don't have any other way to gain status here. And so, say you, of course, you have to disclose that you're married. You have to disclose that the spouse is a citizen on the form, which is called the G325A form. It's a biographic type of form for deferred action. And and keep in mind though, you don't just fill this out and go ask the immigration for deferred action. You have to qualify. And this is one of the reasons why consultation is going to be required, because if you apply for relief for deferred action, but at the same time it's clear that you may have access to gain permanent residence through your spouse, then that deferred action may very well be that deferred action requests may all be for nothing, because they may find that as a basis to deny you that you do have a route to gain legal status. So get legal advice. Let's get more context on what your situation is and what your plans are going in the future. And I can't stress enough that you need to do yourself justice by getting legal advice in a consultation, because that's where you're going to be able to protect yourself. You're going to know how to move forward, and you're going to be able to get an advocate who can help you navigate these complex situations, complex scenarios, complex possibilities. All right. Can undocumented persons travel to Puerto Rico with a state ID? Now, the Puerto Rico is definitely it's uh, a territory of the United States, and people in the U.S. can travel to Puerto Rico without having to show a passport and enter the U.S. without showing a passport. That is the case for Hawaii and the U.S. Virgin Islands as well. Um, Whether it's advisable for undocumented individuals to do that is going to depend on that undocumented individual's immigration history. Because some can travel, yes, some can travel quite fine with the ID, but is it advisable based on your particular circumstances? Do you have a past deportation record? Do you have a past criminal record? Would you show up as wanted by either ICE or law enforcement? So, I usually reserve this advice for my clients when my clients are coming to me and they are telling me they want to do this or they want to do that, they want to travel here, they want to travel there. I have to look at my client's situation and advise them. But I can't give a broad piece of information, a general information saying, oh, yeah, go ahead, go to Puerto Rico. Because I would want to know first, what's the situation? What's the background of the undocumented individual? So I would say it's on a case by case basis, just because the risk might be greater for some undocumented immigrants than others. So the new deferred action that came out, so I think you're talking about the labor enforcement deferred action. This is where if you have reported or you are going to report labor violation, or you've been the witness of labor violations, and you're going to go ahead and report that to to an agency that can look into it, you can then apply for deferred action. Now, once again, that's going to depend on what your plans are for the future, what avenues do you have? What is your marital status? Are you married to the citizen now? All of those have to be addressed in a consultation. In order to get in touch with me in the consultation, go to the link in the profile and you'll be able to click on the link, schedule your own personal consultation to be able to talk about your situation and get particular legal advice and representation through your process. How long does it take to get the work permit through VAWA after the biometrics? So I usually count from the time that the application was filed, but just because biometrics are all over the place. Some will get it like a month later, some will get their biometrics 2 months later. And so it's hard to, have a reliable timeline from the biometrics appointment. But what I can say is it's taking anywhere from 6 to 12 months to be able to get the work permit through VAWA. Um, oh, my friend mom brought her to the country and didn't file for her. She's now over 21 weeks. Um, her visa expired. She never left the country from her mom brought her here. Now, if that's the case, I would want to talk to, if you have a child who's undocumented, we need to talk. There may be various avenues for relief, but I need to understand what the situation is. Why was she brought here, for example? What's the situation with her parents right now, and so forth. So while there is relief for undocumented children, it's going to depend whether that relief is available for your child, or this child is going to be dependent on the circumstances. All right. How soon after getting divorced would you advise getting remarried? So, that is more of a personal type of question. But in immigration, what usually happens is if say you are a permanent resident and you received your permanent residence through a spouse, and then you get divorced right away. Then say you have someone else that you would like to marry and petition for, really they're going to deny that petition, or the preference is to deny the petition, unless you remarry and file for this new spouse 5 years after the divorce, after you have gotten your permanent residence. So your permanent residence needs to be 5 years old. This is a law that's in place, so they are supposed to deny it unless you can meet a very high standard of a very high standard showing that the marriage is real, not only your current marriage, but that the previous marriage is real, by clear and convincing evidence. That's a very high standard. Usually, you just have to show that it's real, more likely real than not. But in this case, you have to show clear and convincing evidence that not only your marriage is real, but the previous marriage was real, which means that it's opening up a can of worms. They're going backwards. This can lead to them opening up an investigation into your matter. So you have to be careful in that regard about getting remarried right after getting permanent residence through a spouse. How long does it take to get the work permit through marriage-based adjustment of status? So I've seen anywhere from 2 weeks, so 2 to 3 weeks. That's the record for me. It's not the usual, but it is a record. But I have also seen in the marriage-based process as long as 8 months. So I would say the average is 6 to 8 months to get the work permit through marriage. A petition is being filed for me, but my visa about to expire. Is it safe to renew it? It's going to depend. I have seen individuals get the visa even when they have papers being filed, but usually it's not really successful when you're just about to, the petition is just about to be processed for the visa, for the immigrant visa to get the green card. But where it takes a very long time, they tend to then, give you a chance, uh, if you can convince them that you will not come to the US and stay. So you have I would say that you still have an up, you you have to go up, you know, you have an uphill battle when it comes to proving that you don't have immigrant intent when you're applying for a visa at the same time that you are applying for your permanent residence. All right. So keep those questions coming. I'm just going to be here a little bit more. So put those questions in the comments. Now is your chance before I leave. Um, if you would like to get in touch with me to discuss your options to get status in the United States, then go ahead and go to the link in the profile and you will see everything you need in that link. You can go to the website and you'll see the phone number, you'll see online chat, you will see the contact form that you can complete. And all three lead to the scheduling coordinators that will be more than happy to help you to schedule your appointment. The other easy way to get in touch is just to schedule your own appointment. You don't need to call, you just go ahead. It walks you through an easy form, and then you confirm your appointment with me, and you're on my calendar, and I'll be ready to advise you when you are on my calendar. So go ahead and do that now if you would like to discuss what your options are. All right. Okay, so I see one here. Can you talk about the prima facie? So the prima facie determination letter, it's a great letter. It's a good sign. I like to describe it as a pre-approval. It doesn't mean you've been approved, but it means that they're moving towards approval, but they have to review, go through your application with a fine-tooth comb to make sure that everything is consistent and true, and that you do indeed qualify for it. Now, the other function of the prima facie in some states is that it does allow you to be able to get certain public benefits. And so that's the reason that they issue it, is to, they understand that you may be in a bad situation right now because the basis of a VAWA is that you're being mistreated. And in this case, sometimes that means that you had to leave the home, you had to be in a shelter. And so in a case like this, some states do provide food stamps, for example, housing, maybe even a driver's license, in order to assist you to settle and have a good, settle, be stable, and be able to move forward in the United States while you wait for your application to be decided. So, all right. Okay, so that's going to be it for me. Go ahead and schedule your consultation, and I'll be back tomorrow to talk to you about another topic. So thanks everyone for your time. I'll see you tomorrow. Bye bye.